to defend the kind of states' rights federalism that Professor Barber has described. No Calhounite, but there is, I think, an alternative to the kind of national federalism that he did describe. And I'm going to claim that that was the founders' constitutionalism, or the founders' view of federalism, which was meant to prevent unlimited government, or the kind of centralized bureaucratic state that we have today. On the other hand, I do want to emphasize that the founders believed that federalism was instrumental. Federalism was not something that was an end in itself or good for its own purposes, but it was meant to protect a more fundamental value, the value of liberty. And that federalism can indeed become destructive of liberty, or of the things that people establish governments for. And Professor Michael Grewcock, who's I think going to talk tomorrow, has written at length about that, the way that federalism can become destructive rather than preservative of liberty. The founders, and I think you can see this in the Declaration of Independence, in many of the revolutionary political statements, believed that government needed to be kept limited, that the revolution was a revolution against a centralized administrative power. If you read the Declaration of Independence, it complains, maybe a bit unfairly, that the king has sent hither swarms of officers to eat out our substance. And that's the kind of government that the founders were trying to prevent. So they had a very decided animus against a centralized administrative state. To some degree, they overdid it, and some of the mistakes that they made in the Articles of Confederation and the state constitutions were because of an exaggerated fear of centralized, and especially of executive power. And one of the things that the Constitution does is it sort of corrected for the excesses of legislative tyranny, and of a legislature that was interfering in the details of administration, and tried to establish a greater balance between executive and legislative power. But I think the main thing for the framers of the Constitution was that the Constitution would give us the benefits of centralized government, or of a unitary state when it came to foreign affairs, but to leave domestic affairs to state and local authorities. As Professor Barber mentioned, and we talk about at greater length during the Q&A, I'd just like to read a very short section from Federalist Number 9, where Publius talks about this the advantages of this kind of never-before-seen combination of a confederal government and a unitary state, which they took from Montesquieu. It is very probable that mankind would have been obliged at length to live constantly under the government of a single person, had they not contrived a kind of constitution that has all the internal advantages of a republican, together with the external force of a monarchical government. I mean a confederate republic. This form of government is a convention by which several smaller states agree to become members of a larger one, which they intend to form. It is a kind of assemblage of societies that constitute a new one, capable of increasing by means of new associations, till they arrive to such a degree of power as to be able to provide for the security of the united body. A republic of this kind, able to withstand an external force, may support itself without any internal corruptions. The form of this society prevents all manner of inconveniences. And I think this is what leads to Madison's description in Federalist 39 of the compound republic, of the idea that we are one polity when it comes especially to external affairs, but we are several when it comes to internal affairs. And the expectation of the founders was that the states would jealously guard their police powers, right? The all-purpose power of government, the reserved powers of the states, right? The power to legislate and regulate the safety, health, welfare, and morals of the people. And thus, if you look at the structure of the Constitution, you find federalism, or the principle of this division of powers, throughout the Constitution. These are the many auxiliary precautions that Madison says were built into the Constitution to keep the government limited. And that you find these principles of federalism, or divided power, within these auxiliary provisions as well as among them. In other words, not only are we separating power between the various branches of government and the different levels of government, but also within each of these structures of government, that there's more than just a double security for the rights of the people in the Constitution. We've mentioned already the enumeration of powers in Article 1, Section 8, and the way the 10th Amendment reiterates that. Every question of federalism is really the question of whether Congress is limiting itself to its enumerated powers. What are the reserved powers of the states? Bicameralism, not only is Congress separated from the state legislatures, but Congress itself is divided, and the states as states, before the 17th Amendment especially, are in the national legislature. The Electoral College, the way we choose the president. And the founders believed that most of the time, nobody would have a majority of the Electoral College, so the states would essentially choose the president through the House of Representatives. And even when this system was sort of preempted by the development of parties, political parties, by which you could normally translate a popular majority into an Electoral College majority, we should remember that parties themselves were principally state and local governments until well into the 20th century. The Supreme Court and the federal judiciary, for a long time before the 20th century, there was a de facto regional representation within the Supreme Court. Right? You couldn't have all the justices come from Massachusetts or New York. They were distributed among the country according to a region. Today we use other factors to represent justices. And of course, the amending process, the process of formally amending the Constitution, cannot be done without the states. So every part of the Constitution has some sort of federal element in it. What I really want to talk about, though, is what happened. How did this system of the compound republic and of the states defending themselves against the establishment of a centralized administrative state, how did that break down? After about a century or so, late 19th into the early 20th century, we began to see the emergence of the modern administrative state. For the most part, the answer is the states did it to themselves. That state politicians began to see the advantages of giving the federal government more power, especially the federal government being able to share revenue with the states. So mostly it is the states sort of gave up their reserved powers for the benefits that, again, state politicians saw coming via the redistributive fiscal policies of the federal government, especially after the 16th Amendment. This is why the Income Tax Amendment is so important. It's also due to the fact that many of our constitutional inhibitions were loosened by new political and jurisprudential theory in the 19th century. This is where the school of thought, various schools of thought that you can group together as progressivism, began to erode at the way that people thought about the theory and the structure of the Constitution. Within the legal field in particular, schools of thought like sociological jurisprudence and legal realism, the law schools and the judiciary began to adopt again, political theories that were at odds with those of the founders. Another very important reason for this was, at the end of the 19th into the 20th century, you began to see more of a blending of foreign policy powers into domestic affairs. You could see this earlier in the 19th century, especially in immigration law. And there are many legal scholars who are doing very interesting work talking about the origins of American administrative law in immigration law in the late 19th century. That when it came to dealing with Chinese immigrants especially, basically anything that the Immigration Bureau wanted to do was okay. The kind of discretionary, flexible power that bureaucracies are supposed to have, you could see first in immigration law. Right about the turn of the century, with American imperialism, as the United States became a world power, you began to find more articulate arguments against constitutional or limited government. The nearly constant wars of the 20th century become one of the reasons why American government, the American federal government, has become more unlimited. If any of you flew here to this conference and you went through the airport, dealt with the transportation authorities, you can see what the administrative state is like. That kind of sort of unlimited power, and also seeing the way in which how quickly people can sort of accommodate themselves to that, how used we have become to that kind of power. Another reason why this occurred was in late 19th and early 20th century America, there was a series of popular crusades against various vices by which Congress began to acquire power that was really the police power of the states. Congress enacted laws to control gambling, for example, under its power to regulate interstate commerce because gambling was so widely regarded as an evil. To combat prostitution, Congress passed the Man-White Slave Act in 1910. It was something that was clearly trying to regulate the morals of the people, but was accepted because it was so widely unpopular as an exercise under Congress's commerce power. Congress also used its taxing power to do away with dangerous products in the national market. Things like phosphorus matches, narcotics were controlled by the taxing power, and that very dangerous article of commerce, oleomargarine, was one of the things that Congress acted upon in these years. So by the foreign policy powers, by the taxing powers, by the interstate commerce powers, Congress began to expand its field of operations. But mostly it came about through what used to be called the grant in aid, or federal revenue sharing, the spending power, as it's sometimes called, where Congress would give money to the states in order to get them to do things that Congress could not do. In the early decades of the 20th century, to get the states to do things like build roads, to improve their educational systems. The first federal involvement in health care came about by the federal government sharing money with the states. One good example of this was when the Roosevelt administration, FDR's administration, was trying to come up with a basis for what is today the Social Security system. Justice Harlan Stone, who's on the Supreme Court, told Francis Perkins, FDR's Secretary of Labor, just use the taxing power. You can do anything by Congress's power to tax and spend. And that was the genesis of Social Security. And Social Security gradually expanded from a very small program in the 1930s, acquired more and more beneficiaries, provided more and more benefits through the 1950s. Medicare and Medicaid in the 1960s, Medicaid especially is a grant-in-aid program, a federal revenue sharing program, was the next step in this. And we've just seen the latest step of this in the Affordable Care Act in the last couple of years. And I want to conclude with that as an illustration of this, how the Affordable Care Act and Supreme Court decisions upon it very recently are the best illustrations of how we got the administrative state and the way in which the Supreme Court has helped complete this. In the Sebelius case in 2012, the court said that Obamacare could not, and the individual mandate especially, could not be justified under Congress's power to regulate interstate commerce. And that was something that states' rights advocates, conservatives liked. On the other hand, the Supreme Court said that it could be upheld under the taxing power. Even though Congress swore that this was not a tax when they enacted it, the court reversed some of its previous decisions about this and upheld it as an exercise of the taxing power. And then the kicker in the Sebelius decision was the Supreme Court saying that there were limits to the strings that Congress could attach when it gave money to the states. In other words, it couldn't threaten to wipe out all of these states' Medicare funds if they didn't augment their Medicaid programs according to the text of the act, right? And many states did do exactly that. They did not establish state exchanges under the Affordable Care Act, but then the Supreme Court undid this most recently in the King versus Burwell case, where it said, well, for the purposes of rescuing this, we are going to interpret the language of that statute of state exchanges as being the same as federal exchanges. So the Supreme Court has been throughout the 20th century instrumental in preserving the way that the administrative state has come about. So for the most part, I would say the way that the states have done this to themselves, or at least we can say state politicians have done this to themselves, by acceding to these various exercises of congressional power, interstate commerce, but mostly through the taxing and spending. So this has mostly been a fiscal process. Thank you.